An important issue or an important area in vicarious liability is the issue of whether the employer should still be liable even though he has given prohibitive instructions. So for example, the employer may have specifically stated that the employee should not use the company's car maybe in a particular way. For example, he may have said that you cannot use the company car after 5. So in that case, if the employee uses the company's car after 5, and in the course of using the company's car after 5, he is involved in an accident, and this accident results in damage to another person's car, should the employer be vicariously liable for the damage to that car? There are a number of cases that show divergent opinions on this particular issue. First, there is a case of Limpus versus London General Omnibus, in which case the driver was prohibited from overtaking other cars. And he did overtake the cars, and that resulted in an accident. The employers refused liability and said that because they had prohibited him from doing the act he engaged in, from the very moment he engaged in that act of overtaking, he had gone out of the course of employment, as a result of which they could not be liable for whatever injury that has occurred. The court said that giving contrary instructions or prohibitive instructions does not absolve you of liability. That alone was not enough. In another case, Rose versus Plenty, the court said that the means by which the employee had chosen to do the work he was authorized, in this case the employee was a milkman and he was employed to deliver milk, and in the course of employment he was told not to hire the services of other people. He hired the services of a child, a 14-year-old boy, to help him deliver the milk, and in the course of delivery this 14-year-old child suffered some injury. The company said they could not be liable because they had given instructions to the contrary. They advanced the same argument that was given by the company in Limpus, but it was not successful for the same reasons. The court also added that the way in which the employee chose to honor or to follow his master's instructions or his employer's instructions could be said to be a wrongful way of following his master's instructions, or a wrongful way of doing something that his master had employed him to do. In this case, what was he employed to do? Deliver milk. And he employed the services of a 14-year-old child. That was wrong, but he was still delivering milk, so he was still in the course of employment. And so because the injury occurred in the course of employment, then the employer would still be liable. In Harrison versus Michelin Tire Company Limited, the court said that at any given time, the determination of whether the employer should be liable, even after he has given prohibitive instructions which the employee has violated and which has now resulted in injury or damages to another person, should be whether by going contrary to the master's instructions, the employee could be said to have gone outside of the course of employment, and the test was that of the reasonable man. Should the reasonable man, having regard to the circumstances of the case, the instructions, the flouting of the instructions, and the resultant injury or damage, would the reasonable man think that the actions of the employee were so divergent as to be distinguished from the employment? Or you could say that, or the reasonable man would think that it was so divergent from what he was employed to do that he could have been said to have gone outside of the scope of employment the moment he went against his master's instruction. So this case gives some sort of a test to determine whether the fact that an employee acted contrary to his master's instructions is a reason why the master would not be vicariously liable for the damages or for the injury that has resulted out of the employee's actions. It says that the determinant is whether by reason of going contrary to his master's instructions, he has gone out of the course of employment, seeming to suggest that you may go contrary to your master's instructions, but you may still be considered to be in the course of employment, as a result of which your master would still be vicariously liable. And that is what seems to have happened in the Rose v. Plenty case. But sometimes you may have gone contrary to your master's instructions, and that alone would have taken you out of the course of employment, as a result of which your master will not be vicariously liable for your conduct. At the start of the video, I said that vicarious liability generally arises as between employer-employee relationships, but it can happen outside of that as well. For example, if you give your car to someone and the person knocks another person down or is involved in an accident, should you be liable vicariously for the accident because it's your car that the person is driving? Well, not necessarily, not all the time. In Morgans versus Launchberry, the court said that the test was whether the person driving the car was under a delegation of task or duty by you. So was the person driving because you had asked them to drive with a certain interest of yours in mind? Okay, so if I'm going to give a very loose example, it's going to be maybe you ask the person to get something for you, so that in the course of driving the car, the person could be said to be your agent because he was driving with your interest in mind. You can read the case of Abuaku versus Tete, a Ghanaian case, which explains these kinds of situations very well. But then, like I said, the general rule is that it depends on whether the person was acting under your instructions. Did you delegate a duty to him, for which reason the person had to use your car or anything of that sort? In that case, then you could be liable for any injury or any damage that may have resulted as a result of the person using your car or being on that errand for you. This is where we end the video on vicarious liability. Vicarious liability is a little bit confusing because of the technicalities in the rules, but I hope that this video helps in your study. See you again in another video. Bye.